Hey, so in this video, I'm going to go over 13 areas where families can blow up as a result of a specific bequest. Okay, I'm Paul Rabelais. I'm an estate planning attorney. I help our clients get and keep their legal affairs in order. And some people, when they are putting an estate legal program in order, they leave things in equal portions to their 3 children, or they're not real specific with specific assets. But some people, on the other hand, will in their legal documentation provide something like, I leave X to Y, and X is some specific asset, some sum of money. Y is somebody. And there's a lot of potential problems with those specific bequests. Let's go through 13 of them. All of these 13 problems, I've seen them with my own eyes in my own office as I've handled various probates and trust administrations over the years. So this is, real stuff that I've seen. Potential problem number 1 with a specific bequest is when somebody leaves their home. Let's say in their will, they say, I leave 123 Sesame Street to Ellen. And then subsequent to the writing of the will, they sell 123 Sesame Street and move into another home. And then when they die, Ellen is homeless. So perhaps if they had intended Ellen to have whatever home they had when they died, they could have said, I leave 123 Sesame Street to Ellen, but this bequest shall include any successor or replacement home that I have when I die. Number 2 is sometimes a bequest of a home is made to a specific person, but it doesn't address whether the mortgage needs to be paid out of the residuary estate. So someone says, I leave 123 Sesame Street to Ellen, and I leave the balance of my estate to my 3 children equally. Person dies, they owe $150,000 on the mortgage. So do the 3 people who were to receive the residuary estate have to use those funds to pay off the mortgage on the specific bequest of the property? Or does Ellen, if she was the recipient of the home, have to go out and get a new loan to cover the loan that the testator had on that piece of property? So a lot of ambiguity here. And the problem is whenever it's not real clear and it's ambiguous, then people start to get stressed. They start to say, well, I'm being shortchanged here, or that's not what so-and-so would have wanted, or that's not fair, or that's not what this says, or we got to all lawyer up and fight this out, and then, families fall apart. So that's the problem with specific bequests when they're not done exactly right. Sometimes a parent may say, I leave my home to Ellen and I leave everything else to my 3 children equally. Person dies, home goes to Ellen, but the bequest didn't address the contents of the home, and that's a completely separate thing. So Ellen gets a home, but she's got to sleep on the floor because the people who were entitled to the rest of the estate go in and get all of the contents out of the home because the bequest of the home didn't include the contents, the furniture, the artwork, all those things that were in the home. So sometimes that messes up and causes some friction. Number 4 is when maybe mom says, I leave my 2019 Cadillac to Cecile and I leave the rest of my estate to my children equally. And then after mom writes the will, well, she goes out and she trades in her 2019 Cadillac and gets a 2022 Lexus. And when she dies, now Cecile has no car to drive because maybe in the will, mom should have said, I leave any vehicle that I own when I die to Cecile. So be careful about that. Here's a big one that can really be a problem. It's problem number 5. It's when, let's say, grandparents, they want to acknowledge their grandchildren with relatively maybe a minimal bequest because they want to leave the bulk of their estate to their children. So they say, I leave 2% of my estate to each of my 6 grandchildren, and then I leave the rest of my estate to be divided between my 2 children equally. And so the person dies, grandchildren are entitled to 2% of the estate. Sounds easy enough, but then the estate consists of things that are really difficult to value. Sometimes home and land can be difficult to value. Businesses can be really difficult to value. So I can see a situation where one or more of the grandchildren may disagree with the valuation of one or more of those hard to value assets. And the grandchild may say, I get 2% of the estate. I think you're valuing the estate wrong. I need it, I want to get it, reappraised or revalued, so I make sure I get my full 2% worth. So that, creates a lot of conflict, difficulty there. Maybe the grandparents should have said, I leave, 2% of my financial assets or 3% of my bank accounts to my grandchildren. And, it's pretty easy to determine what 3% of the bank accounts is, because you just add up the bank balance, divide it, apply the appropriate percentage, and you're not trying to apply a percentage to a difficult to value item. So that's number 5 problem of 13 problem, number 6. Okay, and in fact, I may even, if you stay with me, I'm going to give you a bonus problem at the end. Number 6 is looked at not so much when the grandparents just simply want to acknowledge the grandchildren, but sometimes the grandparents say, I want to make sure all my grandchildren's education is provided for. I want to leave $200,000 to each of my 6 grandchildren. I leave the rest to my 2 children equally. But after this will or trust is written, market downturn, grandparents get sick. So when grandparent dies, they only have $1.1 million in their estate. Well, the grandchildren are going to get everything, 6 grandchildren, $200,000 apiece. There's not even enough to cover that, and the specific bequests are satisfied first. And so all of the estate goes to the grandchildren. The children get nothing. Be wary of large specific bequests of money. Number 7 is leaving a bequest to a minor. I leave this piece of property to my grandson, my great-grandson, and when the testator dies, that grandson, that great-grandson is 11 years old. And a minor cannot own property in their name. So then extra court proceedings are necessary to establish court-appointed guardians for the minor's interest. It is a nightmare. If you're going to leave things to a minor, leave it in a trust for them where you name perhaps a trusted, no pun intended, relative or family member who can serve as the trustee of that minor's trust until the minor is old enough to own it in their own name, and that eliminates a lot of the court bureaucracy. So never leave a specific bequest to a minor. Number 8 is I leave my XYZ bank account to Fred. And these days, XYZ bank, it merges with another bank. It gets bought out. And so that bank account doesn't exist when the person died. And so this intention to leave someone a bank account, simply because of a corporate merger, whoever you left that to winds up getting nothing. Here's number 9, is a bequest of shares of stock. So here's one where I leave 100 shares of ABC Corporation to so-and-so. And then subsequent to the making of the will, again, ABC Corporation either merges into another company, goes bankrupt, gets dissolved, or maybe just the stock splits. And when it splits, the bequest is now half. If it was a 2-for-1 split, the bequest is now half of what it originally was. So be wary of the specific bequests of stock, corporate stock. Another is be wary of a bequest to a sibling or maybe someone even in an older generation than you. Who may be in a nursing home and on Medicaid when you pass away. So if you leave a sum of money to a sibling or to an aunt or to an uncle and you pass away, and those persons that you leave that sum of money to are on Medicaid in the nursing home, what will happen is they'll get kicked off Medicaid. They'll have to get the bequest. They'll have to spend down all of that bequest until they spend it down and have less than $2,000. Then they have to reapply for Medicaid. Better if you had left them nothing. Don't ever leave an inheritance to anyone on Medicaid or on long-term care Medicaid. Potential problem number 11. Same issue, leaving a bequest to a sibling, someone in the same generation as you, or someone who's perhaps even older than you. There's a pretty good chance if you have 4 siblings and maybe you've been very successful, maybe you don't have children, or maybe you have children and you've been very successful and you want to share it with your siblings, and you leave a bequest to each of your 4 siblings, there's a pretty good chance that one of those siblings who's in the same generation as you, obviously, there's a pretty good chance that at least one of them is going to die before you. So what happens to that bequest? And at least here in my state of Louisiana, what happens to the bequest of someone you leave something to if they die before you? It all depends on their relation to you. So may need to specify that in the documents as to what happens. And I say to the people who are of the same generation or an older generation to you, just because those are the people that are most likely to predecease you. Another one, I'll call it number 12, is the problems with the charitable bequests. Some people want to, help their favorite church, charity, university out of their estate. So sometimes people will say, boy, my mother died of cancer. I want to leave $10,000 to the Cancer Society. Well, there's probably 1,000 cancer societies, and so you need to be really specific as to the precise organization that you leave things to. Some of the really big charitable organizations have local organizations, regional, national organizations, so you got to be real specific about that. And then the other caution is about half of the people who would like to help a charity when they die, when presented with the option, about half of the people would like to restrict that charitable donation to be used to fund specific things at that charity. I want to leave $50,000, a will might say, to my university to fund a scholarship in the engineering department. So about half of the people, when given that opportunity, they want to restrict their charitable donation. The other half will say, let's let the church figure out how they best can use it. We'll leave it to their general fund. So we got to be careful about that. And then number 13 is we see this sometimes, particularly here in a community property state like Louisiana. Let's say grandpa, raised his grandchild on what he calls his farm. He has a 20-acre farm that he and grandma bought a long time ago, and grandson loves it. So grandpa provides, I leave the farm to grandson Billy Bob. And then grandpa dies, and everybody quickly realizes that grandpa didn't own all of the farm. He only owned half of the farm because he owned it with grandma. Sure, grandpa called it his farm, but they bought the property while they were married. And so Billy Bob only gets grandpa's half of the farm. Now what does grandma do? Does she donate her half of the farm to Billy Bob, potentially having gift tax consequences? Or, if grandma does nothing, maybe when she dies, her half goes to grandma's kids, and now grandma's kids own half and Billy Bob owns half. So be wary of the married person who wants to leave an asset to someone when they don't fully own that asset. And then number 14, maybe the biggest problem of all is there may be no more educational estate planning videos coming to you from me unless you hit the subscribe button, the notification bell, and give it a big thumbs up to really please those YouTube algorithms. We don't want to disappoint the YouTube algorithms out there. Want to keep them happy by subscribing and giving it the thumbs up, so make sure you do that. Okay, so just be careful if you really intend to make a specific bequest. I will tell you what a lot of people do, particularly for those non-titled personal effects. I want my stamp collection, I want my guns, I want the armoire. They put that stuff in what I call a side letter. While the legal documents may say that the things go to the 3 children equally, simple enough, there's this side letter that says something like, hey kids, in my legal documents, everything goes to the 3 of you, and I have this non-binding side letter. I add to it, I change it all the time. It's not a legal document. It's just a letter to my children asking you to honor my wishes regarding some non-titled personal effects. So here's what I'd like you to do, children, even though the legal documents say the 3 of you get everything equally. In my side letter, it might say, children, I want you each to give $500 to each of your children out of your share of the inheritance. I want to make sure that my grandson Timothy gets the armoire. He really likes the armoire. I want to make sure so-and-so gets the wind chimes. And that's all in a side letter. It doesn't clutter up those legal documents, and it doesn't clutter up the probate with a whole bunch of extra participants. So be aware of the possibility of using a side letter to cover some of those things that have maybe more sentimental value and less fair market value. So be careful with your personal bequests. 10 a.m. Central Time every morning. Check in on YouTube, my YouTube channel, more estate planning educational videos. We'll see you tomorrow.